Good evening. My name is Oscar Carmona. I'll be the one presenting today for Philosophy of Law presentation. Let's get started. Introduction. There has been a growing tension between personal liberty and collective security within our modern world, with its issues raising questions of legal and philosophical dilemmas, especially post 9/11, with the enactment of the Patriot Act of 2001. Large scale debate regarding how much of our own privacy are we, the people, willing to give for the sake of security and order, and when it is considered government outreach. With the technology and corporations like Palantir, which has been known to work alongside the US to assist in surveillance, providing their own technology, being able to use geolocation tracking, facial recognition from almost every single security camera, and backdoor access to mobile devices on regular citizens, is it even possible to have a private life anymore, especially since they keep pushing for more and more laws that increase surveillance for the sake of protection. Furthermore, how do certain legal philosophies such as John Stuart Mill's harm principle and natural law v. legal positivism are able to change or even justify this issue in our perspective? And lastly, what court cases have occurred that have limited the powers of the government? My main argument being, while it is true that we live in a social contract society where we, the people, voluntarily remove some of our own rights for the state and federal government to be responsible for ensuring our safety to us, the introduction of extreme surveillance for the sake of protection completely destroys or undermines any innate right we have to privacy and autonomy, completely disregarding Kantian ethics. For Immanuel Kant is known to speak that people should not be treated as a means to the end, meaning we can't treat people as a way to get something. We gotta sacrifice people stuff to get security. It doesn't work like that. He values autonomy, you know. Rather than, therefore, leading to the corrosion of the foundation of trust people have for the government. The notion that extensive 24/7 surveillance can prevent crimes and terrorist attacks doesn't take into account the massive ethical issues it has, from abuse of power, governments being able to target people without people batting an eye or raising concerns. Furthermore, the issue of natural law. I believe a constant surveillance violates natural law because constant surveillance on people is immoral. Law and morality are linked. Therefore, if something is immoral, it shouldn't be a law. At least that's how the philosophy works. The counter argument, however, regarding this is through the means of legal positivism and harm principle, as they provide a justification for this. Legal positivism, for instance, argues that as long as laws are passed by the proper legal channels, they are legitimate, despite its moral status. As long as it aids in the people, as long as it's passed in regular channels, it doesn't matter. It doesn't matter if it's immoral, because the viewpoint is morality and laws are separate. They're not combined. It's the inverse of natural law. Harm principle values the safety of the people above all else. The justification for surveillance is that through intense surveillance, it can prevent future attacks, future foreign attacks, crimes, prevent crimes before they even happen. If those crimes will lead to the harm of the people, harm's principle comes in and validates extreme surveillance. Court cases are imperative. They are the backbone of the U.S. and restricting the U.S.'s powers, the government's powers. Way too often have we found the U.S. to be simply outreaching, hoping that no one would notice or no one would even bother talking about it. Now, the court cases here is Carpenter v. United States. In 2018, the Supreme Court ruled that warrantless retrieval of cell site location data violated the Fourth Amendment rule against unlawful searches and seizures, meaning that utilizing technology surveillance, it must still abide by the safeguards presented by the Constitution and additional laws, showcasing that we, the people, still have autonomy our privacy is still protected, even virtually. Now, secondly, NSO Group v. WhatsApp. This is a very concerning case, as it really shows that governments, if allowed to, and tech companies, if allowed to, they will spy on you. They will harvest your data. They will spy. NSO Group was found and exploited glitches in WhatsApp's codes to implement spyware named Pegasus, surveil over 1,600 journalists, activists, and other people of importance, showcasing governments, if not caught, can and will spy on citizens for their gain. But however, their justification for this was harm's principle, as they had reason to believe that the people they were spying on were rioters or potential people who could cause harm to, in general, people. And most famously or infamously is the 2001 USA Patriot Act. Following the tragedy that was 9/11 terrorist attacks, the U.S. expanded their surveillance capabilities, collecting data from people without any judicial oversight for the sake of protection from future terrorist attacks. And this lasted for quite some time. The USA's reasoning for this was simply the social contract. With people fearing more terrorist attacks, the U.S. took upon themselves to sacrifice the people's personal privacy for the sake of national security. Some real life examples, besides these court cases, some like this is pretty extreme. On May 11, 2022, the European Union proposed an act known as the Regulation to Prevent and Combat Child Sexual Abuse, or SAR. Now that, at face value, is very noble. We should do everything we can to prevent sexual child abuse. However, the way they went about this is immoral, as it uses a AI system to have backdoor access to mobile devices to constantly scan every photo taken, every message sent, every file, and even more. Way more. Its original intention is noble, but the means by which you would try to obtain this extra layer of protection can be very easily used for nefarious purposes, alongside corroding public trust. For instance, with large-scale blanket scanning of messages, there's no longer a sense of privacy, for which people tend to self-censor themselves. They become complacent. They don't want to say anything. They don't want to do anything. Because this doesn't only scan for child sexual abuse, it also scans for any various amounts of crime activity. Therefore, messages can be taken out of context, like, oh, if you joked about, weirdly, if you joke about doing drugs, it will flag that. And there's so many false positives that can occur from that, for false arrests following suit, misuse of data. Lastly, the people of the EU felt that the surveillance was immoral, as well as refuting Kantian ethics. Now, potential compromises. Despite the significant dangers of large-scale surveillance on people, completely removing surveillance is debatably a worse alternative. For without surveillance, criminals no longer have the fear of being caught. Thus, a compromises between personal privacy and security surveillance must be created. One that abides by ethical and legal standards. I believe this can be achieved if more judicial oversight was utilized. Transparency is such an imperative aspect of the government. The more people understand what the government's doing, the more they're more likely to come around to accepting what the government's doing. So they don't feel uncomfortable being like, oh, they're always watching me. Secondly, I think surveillance should be proportional to the amount of crime in the area. Like how there's more patrol cars in areas of hotspots of crime. And moreover, thirdly, serious threats that are made on social media should be surveilled, because more often than not, on social media, someone claims to be a shooter, or they say they're going to shoot a place up, and no cops intervened. And guess what? They shot up the place, and that happened. That could have been prevented. But without that surveillance, they didn't. They didn't prevent that. Conclusion. In conclusion, regarding the question of how much personal freedom we are willing to part with for the sake of protection from threats, is a complex question, since technology and the government are ever changing. It's still quite far. The government itself is also still quite far behind in adjusting laws for the internet and technology itself. Especially for cryptocurrency, they still haven't done anything about that. Moreover, we can't rely on laws being built purely on legality or efficiency. It has to be balanced with ethical considerations so that the people feel that their rights are not being trampled on. Court cases like Carpenter v. United States 2018 are imperative for updating the government that we won't allow them to carry on with mass surveillance. For their quest for catching criminals can be turned into overreach. We must be vigilant that we never allow the government's quest for collective safety to distort our freedom, or our quest for freedom to distort our safety. A balance is needed with consideration to legal philosophies to guide us. These are my references, and thank you for watching. If there's any issues with this presentation, please feel free to message me so I can remedy the potential issues if there is any. But that concludes my presentation. I hope you have a wonderful day, a good evening, a good morning, a good night, depending on when you're watching this. So, ciao.